Companies Act, Section 324, Admissibility of Debts and Claims in Winding Up. Section 324 of the Companies Act, 2013 deals with a fundamental aspect of company liquidation: the admission and valuation of debts and claims against the company that is being wound up. This provision ensures that all categories of debts and claims, whether present or future, fixed or contingent, are considered and given due recognition in the winding up process, thereby upholding the rights of creditors and claimants equitably. This section reflects the principle that the liquidation process must be inclusive and fair to all persons who may have legitimate financial claims against the company, even if such claims are uncertain in their value or contingent upon future events. Scope and applicability. Section 324 applies to every winding up proceeding under the Companies Act, 2013, including voluntary winding up, to the extent it applies post-amendments, compulsory winding up by the tribunal, situations involving insolvent companies, subject to the overriding effect of insolvency law in such cases. It ensures that the process of assessing liabilities is comprehensive and reflective of the company's total financial exposure. Key principles under Section 324. Let us break down the provision into its core components. 1. Universal inclusion of debts. The section mandates that all debts of the company, irrespective of their nature, are to be admitted to proof during winding up. This includes contingent debts, debts that may become payable only if a specific event happens in the future, example, a pending lawsuit where damages may be awarded. Debts payable in future, debts that are not due at the time of winding up but are contractually bound to be paid in the future. Debts that are not presently ascertained in amount, such as unliquidated damages or amounts subject to dispute. This comprehensive approach ensures that no creditor or claimant is excluded merely because their claim is uncertain or not immediately due. 2. Applicability to insolvent companies. Where the company undergoing winding up is insolvent, the law of insolvency, which may include provisions under the Insolvency and Bankruptcy Code, 2016, or other relevant insolvency statutes, takes precedence in determining how claims are treated. In such cases, the admission and ranking of debts and claims must conform to the applicable insolvency framework. The objective remains the equitable distribution of assets among creditors as per their legal priorities. 3. Recognition of all types of claims. In addition to debts, the provision also extends to claims against the company, including present or future claims, regardless of whether the event giving rise to the claim has already occurred or is anticipated. Certain or contingent claims, including liabilities that are definite, as well as those that depend on the occurrence of uncertain events. Claims sounding in damages. These refer to claims where the amount is not fixed but is based on compensation for some breach, injury, or loss, example, breach of contract, tortious conduct. By including such wide-ranging claims, the section ensures just and equitable treatment of those who may be entitled to monetary relief from the company, even in the absence of predetermined sums. 4. Just estimation of value. Recognizing that some claims may be contingent, uncertain, unliquidated, not quantified, based on damages, subject to judicial determination, Section 324 provides that a just and fair estimate of such claims must be made so far as possible. This means the liquidator or tribunal must use reasonable methods to assign a monetary value to claims. Expert assistance, such as valuation professionals or legal advice, may be used. The process must ensure that no valid claim is ignored simply due to difficulty in quantifying it. This ensures maximum realization of value and fairness in the final distribution of the company's assets. Objective and rationale. The rationale behind Section 324 is rooted in the principles of equity and fairness to all stakeholders, finality of proceedings, by accounting for all possible claims at the time of winding up, avoiding unjust enrichment of some creditors over others by excluding future or contingent liabilities. By allowing even uncertain claims to be valued and admitted, the section ensures a comprehensive resolution of the company's financial obligations before it ceases to exist. For more details, contact us.